Thank you very much for the invitation. A review of the conference programme this year shows that the conference will cover a host of highly relevant issues in the legal tech field. And those topics will be covered by a stellar lineup of highly experienced and well-known speakers and moderators. The topics include, as you've seen, generative AI for e-discovery, child safeguarding in the digital age, the use and leveraging of technology to innovate legal operations, AI and human performance technology, the limitations and misuse of information retrieval in legal e-discovery, deep fakes, the implications and challenges of those, and finally, empowering legal professionals with choice and how technology is transforming legal operations. Before we delve into those exciting topics, we're going to have a keynote address from Paul Gallagher, Senior Counsel, one of Ireland's, I think, leading legal minds and someone who's embraced technology in his practice as a barrister from a very early stage. He was one of a very small number of barristers who did that. I'll say a bit more about Paul shortly, but I want to take this opportunity, just making a few remarks and offering a few thoughts of my own, relevant, I hope, to the themes that we'll be hearing about today. Judges are very interested players in the field of legal technology. Many of the topics and issues that we're discussing today are directly relevant to the work of judges, including e-discovery and generative AI. Ireland was, as you're probably aware, the first jurisdiction to embrace the use of technology-assisted review, where it was endorsed by the High Court in the case of IBRC and Quinn in 2015, and then subsequently on appeal by the Court of Appeal. Contrary to the impression of some, judges are embracing technology and are working closely with the Irish Court Service in its modernisation programme and with legal practitioners in cases before them to facilitate the best possible use of technology in those cases. The Irish courts were early embracers of remote hearings when COVID hit in March 2020 and have continued to facilitate remote and hybrid hearings where possible. Most of the cases, for example, that I hear are conducted on a hybrid basis, sometimes with some people in court and some people appearing remotely. It's particularly useful for vulnerable people who aren't in a position to get to court, but they can zoom in from their hospital beds or wherever they are. The Court Service Modernisation Programme has led to more Wi-Fi and tech-enabled courts in the country. We now have 165 courtrooms that are tech-enabled, and will lead to more extensive e-filing of papers and paperless cases in the not-too-distant future. Judges have also embraced the use of trial platforms such as TrialView and others, and they're in use in many of the larger commercial trials in Ireland, including the large Russian aircraft lessor cases that are currently at hearing in the commercial court. Relevant to a number of the topics that we'll be hearing about today is the question of generative AI. And the Chief Justice very recently, in June of this year, issued guidelines for judges on the responsible use of generative artificial intelligence, which adopt a similar approach to other jurisdictions where judicial guidelines have been issued, and I might make reference to those shortly. We're all now probably aware of the phenomenon of AI hallucinated cases, where an AI model generates content, such as by identifying cases which appear to be plausible, but which is inaccurate in the sense that the cases do not exist. Hallucinations have been one of the significant limitations of large language models, such as ChatGPT, in a legal context. Hallucinations stem from the pattern matching process of generative AI tools which predict words or phrases based on their training data. The model sometimes generates outputs that are factually incorrect and do not correspond to information in the training data. The hallucinations occur because the models cannot independently verify the accuracy of their outputs and so can provide incorrect or fictitious legal information. The production of such inaccurate information in the legal sphere, such as in the context of litigation, can and does lead to serious problems, such as the presentation of false facts, the identification of non-existent cases, and the misinterpretation of cases and legal precedents. And there's been a lot written about this, and there have been quite a number of cases. It's said that these hallucinations occur because AI models such as ChatGPT have no human-like comprehension of reality. ChatGPT has been described as merely stitching together sequences of linguistic forms it has observed in its vast training data, according to probabilistic information about how they combine, but without any reference to meaning. The providers of these AI tools are aware of the risk of hallucination. For example, the providers of ChatGPT, OpenAI, warn users that while they have safeguards in place, the system may occasionally generate incorrect or misleading information, and that is something of an understatement. There have been a number of well-reported cases around the world where lawyers have run into trouble for using hallucinated cases in submissions or filings to courts, and we see cases in the United States, Canada, Australia, and the United Kingdom. I just want to refer to a couple of those. In the United States, I want to refer to two of perhaps the best-known cases. The first was the decision of United States District Judge Kevin Castell in the Southern District of New York in June of 2023, where he decided the case of Mata and Avianca, a case against an airline. In that case, the judge fined two lawyers and their firm $5,000 each after fake hallucinated case citations generated by ChatGPT were cited in a submission they made to the court in response to an application by the defendant airline to dismiss their client's case as being time-barred under the Montreal Convention. The cases had been found by one of the lawyers on ChatGPT, which he said he had assumed was like a super search engine. When subsequently challenged by the opposing lawyers and by the judge, when copies of the cases could not be located, the lawyers, in the words of the judge, doubled down and did not begin to dribble out the truth until some months later, after the judge had made an order directing them to show cause as to why they should not be sanctioned. One of the lawyers responsible said that he never imagined that the cases could be made up, and that his reaction was that ChatGPT is finding that case somewhere. Maybe it's unpublished, maybe it was appealed, maybe access is difficult to get. I just never thought it could be made up. Ultimately, the explanation was that ChatGPT supplied fake cases in response to prompts given by the lawyers, such as, show me specific holdings in federal cases where the statute of limitations was tolled due to the bankruptcy of the airline. ChatGPT provided only excerpts from the fake cases. Ultimately, 6 fake cases were cited in the lawyers' submissions opposing the dismissal of the case. The cases cited were not reviewed by the lawyers before they put them into the submission. And in his decision sanctioning the lawyers, the judge said, technological advances are commonplace and there's nothing inherently improper about using a reliable artificial intelligence tool for assistance. But existing rules impose a gatekeeping role on attorneys to ensure the accuracy of their filings. The judge held that the lawyers and their firm abandoned their responsibilities when they submitted non-existent judicial opinions with fake quotes and citations created by the artificial intelligence tool ChatGPT, then continued to stand by the fake opinions after judicial orders called their existence into question. And he continued, many harms flow from the submission of fake opinions. The opposing party wastes time and money in exposing the deception. The court's time is taken from other important endeavours. The client may be deprived of arguments based on authentic judicial precedents. There is potential harm to the reputation of judges and courts whose names are falsely invoked as authors of the bogus opinions, and to the reputation of a party attributed with fictional conduct. It promotes cynicism about the legal profession and the judicial system, and a future litigant may be tempted to defy a judicial ruling by disingenuously claiming doubt about its authenticity. The judge found that the 2 lawyers involved had acted in bad faith, and apart from imposing the fines I mentioned earlier, he also ordered them to send letters to each judge falsely identified as the author of the 6 non-existent decisions. The second New York case is also a very well-known one, and this involved an application by Michael Cohen, once a lawyer for former and now President-elect Donald Trump, who was applying to the United States District Court in New York seeking an early end to his supervised release on foot of previous criminal proceedings. It appears that Cohen himself used Google Bard, Google's generative AI tool, and found what he thought were a number of cases that supported his application. He supplied those cases to the lawyer acting for him in the application. The lawyer assumed, wrongly as it happened, that the cases had come from another lawyer who'd been acting for Cohen in a different case, and he included them in his submission without checking them. In complicated circumstances, the lawyer in the other case discovered that the citations were fake and disclosed the problem to the judge, who considered sanctioning the lawyer who had included the fake cases in his submissions. Cohen explained that he of course was a lawyer himself, although disbarred by this point, he explained that he was under the impression that Google Bard was a supercharged search engine rather than an AI program, and that he had previously used it to successfully identify accurate information in other contexts and didn't appreciate its unreliability as a tool for legal research. Cohen again wrongly assumed that the lawyer would vet his suggestions before incorporating them into his application. The judge in that case held that the lawyer's submission, including the 3 fake cases, was embarrassing and certainly negligent, perhaps even grossly negligent. However, unlike the Avianca case, the first case I mentioned, he concluded that it was not done in bad faith, and he imposed no sanction on the lawyer. There are many other examples from the United States where lawyers have been sanctioned for failing to ensure the accuracy and authenticity of their citations and legal arguments, and where courts have emphasized that technological assistance does not relieve the lawyers of their ethical obligations. The first reported example of a similar issue arising in the United Kingdom was the case of Harbour and Commissioners for His Majesty's Revenue and Customs in December 2023. In that case, which was decided by a first-tier tax tribunal in the UK, a self-represented litigant who was appealing a tax penalty provided the tribunal with a number of authorities supposedly in support of her appeal, which were not genuine judgments, but instead had been generated by an AI tool. I think it was ChatGPT. The tribunal noted that the appellant's citations and summaries had some traits that were superficially consistent with actual judicial decisions, but were ultimately found not to be real cases. The respondent in the case gave evidence that it had checked each of the cases referred to by the appellant, but were unable to locate them. The tribunal was also unable to find them. The appellant accepted that it was possible that the cases had been generated by AI and said that they were provided to her by a friend in a solicitor's office who she had asked to assist her with her appeal. The tribunal held that the cases were not genuine tribunal judgments, although they appeared plausible because each case had similarities to real cases. The tribunal quoted from Judge Castell's decision in the Avianca case and made it clear that citing invented or fake judgments caused the tribunal and the other party to waste time and public money, which reduced the resources available to progress other cases and prompted cynicism about and undermined the importance of judicial precedents, an important cornerstone or foundation in most common law legal systems. The tribunal did, however, accept that the appellant was unaware that the cases were fake and concluded that ultimately the issue made no difference to what was an unsuccessful appeal on her part in any event. There are many other examples around the world, including a case in British Columbia in Canada, when in February 2024, in a child custody case, a lawyer was found to have used ChatGPT to prepare a submission which included citations to fake cases. And in Australia, where in another family law case, a lawyer included a number of authorities on a list of cases he planned to rely on in the proceedings. When asked to provide copies of the cases referred to in his list, the lawyer was unable to do so. He informed the court that he had put the list together with the aid of a particular legal software which used generative AI, Leap Law Y. In late August 2024, the judge referred the lawyer to his legal regulator to determine whether disciplinary action should be taken. These issues have led to a number of judiciaries around the world issuing guidelines on artificial intelligence. The UK have guidelines dating back to December 2023, and other jurisdictions such as New Zealand and various Australian states have done so in 2023 and in 2024. Very recently, the Supreme Court of the state of Delaware issued their guidelines by way of a court order in October of this year. So what's the position in Ireland? Well, in Ireland, guidelines were issued by the Chief Justice in June 2024, and they're guidelines for judges on the responsible use of generative artificial intelligence. Noting that generative AI presents new challenges and opportunities for users, including the judiciary, the guidelines stress that it's essential for judges to understand its benefits and limitations. Judges are directed to ensure that any use of generative AI tools must be consistent with the overriding obligation to ensure the integrity and reliability of the legal research analysis which underpins judicial decision-making. The guidelines seek to provide assistance to judges on how to identify and manage the use of generative AI by others, including lawyers and unrepresented parties, in court proceedings. The guidelines set out examples of potential uses of generative AI and note in summary that it may be useful to use public generative AI tools to assist judges with some aspects of their work, such as speeches, sadly not this one, or administrative or routine tasks. But it's not recommended to use such tools for core judicial work, such as conducting research to find new information which cannot be independently verified or for legal analysis. The guidelines stress that the use of generative AI on trusted databases can be a useful supplementary tool in some contexts, but it cannot replace the judgment, empathy, and ethical responsibility of judges in the performance of their judicial role. The guidelines take a similar approach to those in other common law jurisdictions. They explain what's meant by generative AI, how it works, and how it can go wrong. They note, for example, that generative AI is neither confidential nor private, and that the information provided by generative AI models can be inaccurate, incomplete, and out of date. They refer to the risk of those models producing fictitious cases that we just heard of, made-up citations, or quotations and legislation, articles and legal text that does not exist. Judges are urged to be aware of ethical issues and to maintain security, and it's stressed that any use of generative AI by judicial support staff, such as judicial assistants, must be disclosed to the judge. Further, judges are urged to be aware of the use of generative AI by others, including lawyers and unrepresented parties. They stress that provided generative AI is used responsibly and the output appropriately tested and verified, there is no reason why a lawyer ought to be required to refer to its use, but the guidelines note that that will very much depend on context. Judges are advised that particular care is required when dealing with unrepresented parties who use generative AI chatbots to identify and explain relevant law and legal principles, or to prepare basic legal documents in proceedings. They may often not have the necessary skills or training independently to verify the legal information provided by generative AI model. If it appears that a generative AI chatbot may have been used by an unrepresented party to prepare submissions or other documents, judges are urged to inquire whether that occurred and whether checks for accuracy had been undertaken. Various red flags are identified in the guidelines, including submissions that use American spellings or refer to foreign cases, reference to cases that do not sound familiar, confused concepts, and submissions that do not accord with the general understanding of the law in the area. Warnings are also given to judges in relation to fabricated images, audio and videos, which parties could present as evidence, and the potential use of deepfake technology, something that's going to be discussed later today.